question that clauses 31, 32, 33, 34, 35, and 36 be part of the bill? Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 37.
I propose the question that clause 37 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. I propose that clause 37 be amended as shown on the order paper, and what we are doing here is purely to ensure that we comply with the law, the Constitution, by introducing that when the Cabinet Secretary determines what remuneration is to be paid to the trustees, it is on the advice of the Salaries and Remuneration Commission. On the advice. Those are the words we are introducing to make this compliant with the law. I beg to move.
I propose the question that clause 37 be amended as proposed by the chair. I now put the question that clause 37 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 37 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 38, 39, 40, 41, 42, and 43.
I propose the question that clauses 38, 39, 40, 41, 42, and 43 be part of the bill. Honorable members, there are no amendments on these ones. Allow me to proceed and put the question that clauses 38, 39, 40, 41, 42, and 43 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 44.
I propose the question that clause 44 be part of the bill. There's an amendment on this one, Chair.
Yes, thank you very much, Honorable Chairperson. I beg that clause 44, in particular subsection 2, subclause 2C, be amended as shown on the order paper. Here we are simply adding the word after so that it makes sense in that interest that the additional voluntary contributions under the fund, together with the accrued interest thereon, after leaving employment for any reason. That's the word after we are introducing. Thank you. I beg to move.
I propose the question that clause 44 be amended as proposed by the chair. I now put the question that clause 44 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 44 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54.
I propose the question that clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54 be part of the bill. Honorable members, there are no amendments on these ones. I proceed to put the question that clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 55.
I propose the question that clause 55 be part of the bill. There's an amendment. Chair.
Yes, thank you very much, Chairperson. I beg to move that clause 55 be amended as shown on the order paper. And the rationale is this exactly what we are doing. First, we are renumbering so that we have a second subclause. For us to do that, we must introduce subclause 1. Then we have subclause 2, which now as the subclauses 2 and 3, which as the following provisions. A judge of the Supreme Court to whom this part applies shall, during their retirement, be entitled to the additional benefits set out in the schedule. And number 3, subclause 3, a judge of the Supreme Court who leaves office before attaining the age of 65 years shall be entitled to access the non-pension benefits under subsection 1 and the paragraphs A and B of the schedule. The rationale is to provide for enhanced non-pension benefits for a judge of the Supreme Court appointed to office after the commencement of the legislation. The Supreme Court has 7 judges. We know for sure the Chief Justice and the Deputy Chief Justice draw their pension from a different law, and therefore it is important that we make a provision for the rest of the judges. Then the amendment also allows a Supreme Court judge who leaves office before attaining the age of 65, for whatever reason, to access their non-pension benefits, including what has actually been set out in the schedule, to include transport allowance, medical cover, diplomatic passport, and access to government lodges, etc. I beg to move.
Honorable members, I now propose the question that clause 55 be amended as proposed by the chair. And if this one is taken, then the one of the leader will actually fall because they are actually the same. Let's hear from Ridikiri, Honorable Ridikiri.
Thank you, Mr. Chairman. I think today is going to be a history of the law process in this country, because we are now taking a full responsibility of ensuring one of the arm of the government is taken care of. Harmonization is very critical, because we have seen the Supreme Court judges drawing from one kitty and the other judges are not. So this bill is causing harmonization, and that's what we really want. It has been a practice everywhere in the world that there must be sequential harmonization of all the benefits that accrues to the members of the judiciary world over. So I support this and say I think this is the best thing that the judiciary will enjoy this year.
Very well. Honorable members, I now put the question that clause 55 be amended as proposed. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it. I now put the question that clause 55 as amended be part of the bill. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it.
Clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65.
I propose the question that clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65 be part of the bill. Honorable members, there are no amendments on this one, and I therefore proceed to put the question that clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65 be part of the bill. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it.
Clause 66.
I propose the question that clause 66 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. Allow me to move that clause 66 be amended as shown on the order paper. And what we are doing here is to renumber the sub-clauses such that we have a clause 1 in 66 and introduce a new subsection 2, which reads as follows. A judge of the Supreme Court to whom this part applies shall during their retirement be entitled to additional benefits as set out in the order paper. And this is purely to provide for enhanced non-pension benefits for the 2 judges of the Supreme Court that were appointed under the new constitution and have already retired. The 2 judges are not covered by the Retirement Benefits Deputy President and Designated State Officers Act, Chapter 197B of the laws of Kenya. This is the second schedule. We shall be talking to it, the additional
non-money benefits.
I propose the question that clause 66 be amended as proposed by the chair. And of course, if this one is taken, the one of the leader will actually fall. Honorable members, I proceed to put the question that clause 66 be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that clause 66 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 67.
I propose the question that clause 67 be part of the bill. Chair.
Thank you very much, Honorable Speaker. Honorable Speaker, I do propose that clause 67 be amended as shown on the order paper. And what we are doing is to delete clause 67 and introduce a new clause 67 as follows. Clause 67(1), the Cabinet Secretary shall be responsible for the payment of pensions and gratuities to judges under this act. This is purely just to align it with the law that pensions are under the Cabinet Secretary, Treasury. Now, we're introducing clause 2, that the Chief Registrar of the Judiciary shall administer the non-pension benefits under sections 23, 55, and 66 of this act, and they provide for them in the estimates of the judiciary prepared pursuant to Article 173(3) of the Constitution. What we are doing is we must separate the pension, the monies being or coming from Treasury, and the non-monies that are being administered by the Chief Registrar of the Judiciary, the motor vehicles, the security, the cooks, and everybody else. Then number 3, we've combined a responsibility for them that the Cabinet Secretary and the Chief Registrar of the Judiciary shall establish a liaison office to facilitate the timely payment of pensions, gratuities, and the provision of non-pension benefits under this act, purely to facilitate for the judges who are retiring. Where do they go for their pensions? These are old men and women past 70 years. We don't want to keep them out there moving from one office to the other. They need to know where to go. They get their pensions and other benefits one stop. This is the liaison office. I beg to move.
I propose the question that clause 67 be amended as proposed by the chair. Yes, Honorable Meli.
Thank you. I just wanted to correct the chair when he called 70-year-old old. Those are advanced age. They are not old.
Okay, the chair is corrected. Ridikiri, what do you want to say about this?
You know, our judges, and I need stand collected, these people are very isolated by virtue of their work. Sure. So they rarely have so many friends like Mary Odhiambo, because she is all over and she is known all over. Judges leave the office, go to their home and back. Now, these people need to be taken care of. Otherwise, some of them might lapse. Immediately they retire. So these benefits are very important, and they need to be properly managed. They should not go home and start asking, where do I start? They need to continue the life they have been enjoying. So I support this.
Okay, Honorable Gishimo.
Thank you, Chair. I support this amendment. Judges, and especially the Supreme Court judges, having served at the highest level in the judicial system, require dignity. They require an office which can really serve them, having sacrificed their mind, their effort, everything in their life to serve justice in this country. So I support this is a very good amendment, and it will make their life easy after retirement.
Honorable members, I now put the question that clause 67 be amended as proposed by the chair. Will as many as other opinions say aye? Will as many as other contrary opinions say nay? The ayes have it. I now put the question that clause 67 as amended be part of the bill? Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clauses 68, 69, and 70.
I propose the question that clauses 68, 69, and 70 be part of the bill. No amendments. I proceed to put the question that clauses 68, 69, and 70 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 71.
I propose the question that clause 71 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. I beg to move that clause 71 of the bill be amended as shown on the order paper. What we are doing is we delete subclause 1 and substitute therefore the following new clause. That the Cabinet Secretary shall, within 12 months of the commencement of this Act, make regulations generally giving effect to the Act and for prescribing anything required or necessary to be prescribed by or under this Act. That is subclause 1. Subclause 2, we propose we insert the following new subsection immediately after subsection 2. These are clauses now. 2A, in making the regulations under this Act, the Cabinet Secretary shall obtain the views of relevant stakeholders, including the Judicial Service Commission and the Chief Registrar of the Judiciary. The rationale is that within a given period of time, and this must be maximum 12 months, we have regulations in place because we do not want a lot of bureaucracy when these judges, retired judges, are going for their pension. There may be forms to be filled, there may be other processes and procedures to be done. All these are contained in regulations. This is why we are saying that within 12 months, these must be attended to. If there are any set forms and precedents, this must be done within a period of 12 months. Then when making those regulations, the CS cannot sit alone and decide for the retired judges what is good for them. He must take views from the relevant stakeholders who include the Judicial Service Commission that pays them and the Chief Registrar of the Judiciary who administers especially the non-pension benefits. I beg to move.
Honourable members, I propose the question that clause 71 be amended as proposed by the chair. And Honourable Chipukonga, you had a similar amendment, and therefore, if this one is taken, yours will fall, but could we hear from you?
Yes. Thank you very much, Honourable Chair. Chair, I totally agree that once the Chair's proposed amendment is taken, mine will fall by the way. And I support this, Mr. Chair. The reason, Honourable Chair, the reason why I proposed similar amendment, Honourable Chair, is because we want to provide something called certainty and clarity and remove something called doubt and equivocation on matters to do with the law, and particularly when it comes to benefit of judges. So we want to provide certainty in the sense that the Cabinet Secretary should be able to bring the regulations within 12 months of this law coming into operation. That will ensure that those judges who will be retiring have clarity on what they are expected to get, how much they are supposed to get, when, and in which place. I thank you, Honourable Speaker.
Honourable Mtuse.
Thank you, Chair. I stand in support of the amendment proposed to clause 71. Chair, if you look at the original section 71, it is already prescriptive. It was already saying what the regulations would say, which is not very good in legal drafting. And therefore, the amendment to shorten it so that the stakeholders, especially the Judicial Service Commission and the Chief Registrar, in liaison with the Cabinet Secretary, will come up with regulations that are not already prescribed in the parent act, and therefore support the amendment by my chair. It is very timely, it is effective, it is going to make the operationalization of the law easier.
Honourable Gidinji.
Thank you, Chair. While I support this amendment, I don't know whether I would persuade the Chair whether we can do away with Amendment B, because it goes without saying that for you to make regulations, you must do public participation. And this public participation must involve all the requisite stakeholders. So I believe, in my view, the Amendment B, which is seeking that the other stakeholders to be consulted for when the regulations are being made, is already covered under the Constitution, which provides that for any law to be made, whether an act of parliament or regulations, public participation, which must include all the stakeholders, must be involved. I believe this to me is somehow superfluous.
We've heard you, and I'm going straight to the chair to give that explanation, but also tell us, allow chair, also maybe tell us, why is the proposal that the regulations must come in 12 months? Why not a lesser time? Proceed, chair. We shall hear.
Thank you very much. We don't need a lesser time means it's within 12 months, so we are covered.
Okay.
Good enough. What we are doing is we don't want the act to come into force. Another 2 years down the line, they don't know what to do. So it's also 12 months are sufficient for us to do exactly what Honorable Gishimo is saying, public participation and what have you. Honorable Gishimo, for subsection 2A, this inclusion is not superfluous. I think it's very important because we have to consult all relevant stakeholders, but to be particular, because this affects judges whose remuneration is by Judicial Service Commission, and the Chief Registrar of the Judiciary, who is going to administer their non-pension benefits. I think we make it almost mandatory that they have to be included in the consultations that are to take place. This does not affect anything in any manner that is negative.
Very well. Gichimo was feeling like you were over-legislating, but let the matter will rest there. Okay, Gikaria, what do you have to say?
Honorable Speaker, I think the chair has actually, let me just say, it is important to have this regulation, Honorable Speaker.
Okay.
And one of the issues is because we have some Energy Act that up to date, since 2019, regulations have not come before the floor of the House. And we are actually finding it very difficult to operationalize some of the sections of the Act without the regulation. So I totally agree, but I also agree with you, Chair. 12 months is also quite a while. So how I wish.
He was able to answer that one, that within 12 months. So that's the higher limit. It can be in a lesser period. Honorable members, I now proceed to put the question that clause 71 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that clause 71 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 72.
I propose the question that clause 72 be part of the bill. Oh, honorable members, there are no amendments on these ones. I proceed to put the question to be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
New schedule.
We are on the new schedule. Chair, please move the new schedule.
Yes. Thank you very, very, very much, Honorable Chairperson. I beg to move that the schedule to the bill be read a second time. The justification is we start by finding this under proposed sections 23.2, 55.2, and 66.2. Additional benefits for a retired judge of the Supreme Court. I think we've elaborated the hierarchy of the judges in the country, and we find it proper that we do make a provision for additional benefits for the Supreme Court judges. The additional benefits include the following. You will get 1 car, you will get fuel allowance, he or she will get 2 armed security guards provided on request, which means the judge will choose whether they want security or not. get one housekeeper and one cook. And justification is that we have to outline the enhanced non-pension benefits for all judges of the Supreme Court who are not covered by the Retirement Benefits, Deputy President and Designated State Officers Act, Cap 197B. The benefits are slightly higher than those of judges in other superior courts and below those of the Chief Justice and the Deputy Chief Justice. This is where we are placing judges of the Supreme Court, so that they are between the Chief Justice and the Deputy Chief Justice and the judges of the superior courts, the High Court and the Court of Appeal. I beg to move and request Honorable Rindikiri to actually second.
Does it really require seconding? No, Rindikiri will speak to it later. Honorable members, I now propose the question that the new schedule be now read a second time. Honorable Rindikiri, I give you the first chance to make your comments on this.
Thank you, Chairman. I have two comments. One, on the there's a requirement that we consider, in my view, a provision for a driver, because the bodyguard is there, and also the car, the capacity of the vehicle, that the judges will be entitled to retirement. I think that is not stipulated. I would like to ask the Mr. Chairman to consider those two as to be part of the package in the named schedule.
Very well, Honorable Chepkonga.
Thank you very much, Chair. I in fact rise to support the proposed schedule by the Chair. The reason being, Chair, is that, you know, what has been provided as the retirement benefit is in fact very frugal as far as I'm concerned. The reason being, you know, in the United States of America, the Supreme Court judges don't retire. They in fact sit in the Supreme Court until they die. So if they die at the age of 86, 87, so you can imagine, Chair, how much money they draw all that time. If you look at ours, they retired merely at 70. Still very strong, still very useful. They've done a great work for this nation. It is good just to reward 6, 7 people only, Mr. Chairman. I support.
So we hear Gichimu.
Thank you, Chair. These are additional benefits for a retired judge of the Supreme Court. The other benefits that touch on all the retired judges are already covered under the bill, including the car, which Honorable Rindikiri was seeking. So that is already covered, but probably on the matter of the fuel allowance, much as I support, I think that ought also to be determined. I think the regulations in consultation with the Salaries and Remuneration Commission, I think will come up with that bit of the allowance. And Honorable Chair, these are just bare minimum, and Kenyans should note that the heavy lifting that the Supreme Court judges usually do in matters of very national importance. So I think they deserve, and we have, this House will be remembered as having done the best for the judges in this country on matters retirement. Thank you.
Jemachia.
Thank you so much, Mr. Chair. Also, I want to reiterate and add my, on the schedule, that apart from all this, I don't know whether it's possible for the chair of the committee to add another advantage we can have, because when Honorable Chepkonga said,
Chair Murungaru, you're being addressed. Okay.
When Honorable Chepkonga said judges in the US, for instance, are not going on, they don't go for retirement, or they are not retiring, or they don't retire, it means they protect the institution, the memory of the institution. I don't know whether the chairman, you can add one as on the schedule also as a beneficiary, that judges who are able to serve, even in their retirement, can be called back one time to time for institutional memory and to give counsel. Because it is important when these people sit, we cannot just wish them away. That could be added to one of the, so that they can be always coming back to give us the best ruling and judgment. Thank you, Mr. Speaker.
No, Chair, I'll call you later. Let's hear Onchoke first, then we come to you, Chair.
Thank you, Mr. Chairman, and I support these amendments and this schedule for the additional benefits of the Supreme Court judges who are retired. Now, for all these benefits, the driver, the fuel, the armed security guards, one housekeeper, and one cook, I think it would be important maybe in the regulations to give them the amount, so that some judge doesn't decide, I want a cook at 2,000 shillings, at 200, so that it's uniform for all of them. That would be very important, in my view, Mr. Chairman.
Oh, so the two still go to the chair. So let's hear from the chair.
Right. Thank you very much, Chairperson. Regulations will be coming. So most of the concerns we have will be addressed through regulations, which are actually the flesh of any act of parliament. It's regulations that tell us exactly what parliament meant when they made that provision. In those regulations, including rendering some expertise when required, whether opinionated, provided it doesn't go against the Constitution, which provides that their retirement age is 70 years and it cannot be renewed. However, if there's a way this is going to be looked at, there is absolutely nothing wrong. As to what they will be getting in terms of fuel allowance, again, the regulations will make a provision. And even if the regulations will make provision for salaries of the helps, the cooks, the drivers, and what have you, they will be free to do all that. It's for this parliament to approve or disapprove. Thank you, Honorable Chairperson.
Honorable members, I now put the question that the new schedule be now read a second time. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now propose the question that the new schedule be part of the bill. I proceed to put the question that the new schedule be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 2.
I propose the question that clause 2 be part of the bill. No amendments. I now put the question that clause 2 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Title.
I propose that the title be the title of the bill. I now put the question that the title be the title of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 1.
Honorable members, I propose that clause 1 be part of the bill. But there's an amendment by the chair.
Yes. Thank you very much, Honorable Chairperson. I rise on my feet now to move an amendment that clause 1 of the bill be amended by inserting the words, as soon as you name, and shall come into force upon publication in the Gazette, immediately after the expression Judges Retirement Benefits Act. That is how the act is called, and we have made a provision as to when it shall come into effect, when it shall come into force, which is also a requirement of legislation, that we know exactly when this act is going to come into force. It is as soon as it is assented to and it's actually gazetted, it now becomes printed by the government printer, it comes into effect. Thank you.
Honorable members, I propose the question that clause 1 be amended as proposed by the mover. Honorable Mutuse.
I stand in support. Support because this is very important. You know, sometimes you can delay the benefits to the judges by not operationalizing the law. And therefore, this because it now provides a safe mechanism for its own getting effective so that the judges are certain that it will be implemented. And therefore, this is extremely important.
Honorable members, I put the question that clause 1 be amended as proposed by the chair. Will as many as without opinion say aye. Will as many as with contrary opinion say nay. The ayes have it. And I'll put the question that clause 1 as amended be part of the bill. Will as many as without opinion say aye. Will as many as with contrary opinion say nay. The ayes have it. Honorable members, we are finished with this particular one. We ask the mover to move reporting. Honorable Murungara, on behalf of the leader.
Thank you very much, Honorable Chairperson. On behalf of the leader of majority, I beg to move that the committee do report to the House its consideration of the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and its approval thereof with amendments. Will as many as without opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Honorable members, Mr. Speaker.
Thank you, Chairperson. Reporting.
Very well, Honorable Speaker. I beg to report that the Committee of the Whole House has considered the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and approved the same with amendments.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request Honorable Jematia to second the motion for agreement with the report of the Committee of the Whole House.
Thank you, Mr. Speaker. I want to support the whole report of the House, of the committee, and then to second. I want to second the report of the committee. Thank you, Mr. Speaker.
Thank you, honorable members. Thank you so much for your patience on this matter. I therefore now propose the question, which is that the House do agree with the committee in the said report. I would be minded to take any few interventions if there are any. If there are not any interventions, then I would, for obvious reasons, for obvious reasons, I would pend the putting of the question until we are properly prepared to do so. I will therefore call for the next order.
Order number 13, motion, consideration of the privileges and immunities, the Global Center for Adaptation Order 2025.
Who is the mover of this? This is the Honorable Chekonga. I would imagine you still the chairperson of the Legal Legislation Committee. Honorable Gishimu.
And
No, but is it true that he's still the chair?
Honorable Speaker, he is the chair.
But now you are the delegatee this afternoon.
Yes, I have leave to move.
Correct, yeah. So what's the order of paper is that this is moved by the chairperson, and now it's on record that this chairperson is the Honorable Gishimu for this evening. Go ahead.
Honorable Chair, Honorable Speaker, I beg to move that this House adopts the report of the Committee of the Delegated Legislation on its consideration of the privileges and immunities, the Global Center for Adaptation Order 2025, legal notice number 82 of 2025, in accordance with the provisions of the Statutory Instruments Act, Cap 2A, and Standing Order 210. Honorable Speaker, the privileges and immunities, the Global Center for Adaptation Order 2025, is a statutory instrument made by the Cabinet Secretary for Foreign Affairs and Diaspora Affairs, for Foreign and Diaspora Affairs pursuant to Section 11 of the Privileges and Immunities Act, Cap 179. The legal notice was published in the Kenya Gazette on the 2nd May 2025, thereafter submitted to the Clerk of the National Assembly on the 30th May 2025, and tabled before the House on the 4th June 2025, whereupon it is stood referred to the Committee on Delegated Legislation for scrutiny in accordance with Section 12(1) of the Statutory Instruments Act, Cap 2A. The committee considered the order in line with the Constitution, the Privileges and Immunities Act, Cap 179, the Interpretation and General Provisions Act, Cap 2, and the Statutory Instruments Act, Cap 2A. Honorable Speaker, the object and purpose of the privileges and immunities, the Global Center for Adaptation Order 2025, is to confer privileges and immunities upon the Global Center for Adaptation, GCA, an international organization with which the government of Kenya has entered into a cooperation agreement to support climate adaptation initiative. And the order seeks to grant the organization legal capacity as a body, cooperate and confer privileges and immunities specified under Part 1 of the 4th schedule of the Act, which includes A, the immunity for suit and legal process, inviolability of premises and official archives, and exemptions from certain taxes and duties. The order further confers privileges and immunities upon director, officials, and staff of the organization under Part 3 of the 4th schedule of the Act, including immunity in respect of the acts performed in course of the official duties and certain physical exemptions. Honorable Speaker, in its scrutiny of the order, the committee made the following observations. A, that Section 17 of the Privileges and Immunities Act requires that any order made under the Act must first be submitted to Parliament in draft form and approved by resolution before publication. This requirement gives effect to Article 94, Article 6 of the Constitution, which provides that delegated legislation must be exercised strictly within the authority and standards set out by Parliament. And in this case, that authority and standard has already been set out under the Privileges and Immunities Act. Honorable Speaker, the Ministry of Foreign Affairs and for Foreign and Diaspora Affairs did not prepare or submit a draft order to Parliament prior to consideration as required by the law, that is Section 17 of the Privileges and Immunities Act. The order was therefore published without the mandatory prior requirement that Parliament ought to approve it. And therefore, Honorable Speaker, pursuant to Section 16 of the Statutory Instruments Act, the committee invited the Ministry of Foreign Affairs just to give them a hearing and also hear their views on the matter. And also the National Treasury for consultation on this. And actually the National Treasury confirmed that they were not aware whether the order had been submitted to Parliament in draft form as required. And therefore, having examined the Act, the Privileges and Immunities, the Global Center for Adaptation Act 2025, and against the Constitution and the relevant statutes, the committee found that the failure to submit the draft order to Parliament before publication infringed on the Constitution, that is Article 94, sub-Article 6 of the Constitution, which provides the effect of, or which provides that the delegated legislature must be exercised strictly within the authority and standards set out by the Parliament. Of course, in this case, through the Act of Parliament that it is embedded. And therefore, it also contravened Section 11 and 17 of the Privileges and Immunities Act, Cap 179, and violated Section 13A of the Statutory Instruments Act, Cap 2A, which requires that the statutory instruments conform to the enabling law. Honorable Speaker, accordingly, the committee had no option other than to recommend that this House declares the Privileges and Immunities, the Global Center for Adaptation under 2025 Legal Notice number 82 of 2025, nullity for failure to comply with the Constitution and the applicable statutory requirements governing the delegated legislation. Honorable Speaker, however, much as this order may have been well-intentioned, it had to follow the requisite procedure provided under the Act under which it is made. So let me be very clear while moving this and seeking the House to agree with the Committee on Delegated Legislation in annulling this order, that the committee has no or did not dwell into the nitty-gritties of this order, having considered that the requisite procedure was not followed, then it was not necessary now to move into the other issues of whether public participation was conducted, whether all the other requisite conditions for delegated or regulations were made. So we found that the law was not followed, as I've already explained, and I beg to move, Honorable Speaker, and I now call upon Honorable Member for Mbonchari, Honorable Onchoke, to second.
Grace in the House. Go ahead.
Thank you, Speaker. Today I'm sitting here. I've been promoted. I raise, Honorable Speaker, to second the motion that this House considers to nullify the order of the privileges and immunities for the Global Center for Adaptation, order number 2025. On the face of it, about 3 or 4 laws were breached. They were never followed. So the committee didn't even have to go into the merits of this order and the purpose for this order. And the committee...
Honorable Francis, that was Francis Kimani Kuria. You can't do that, and you know it.
And the committee, Honorable Speaker, the committee has noted that a number of these statutory instrument-making bodies have developed a habit of not bringing or following the law, not bringing the orders, the instruments to the House for consideration and approval. I therefore stand here to second this motion. I thank you.
Honorable members, moving and seconding of that motion, I therefore propose the question, which is that this House adopt the report of the Committee on Delegated Legislation on consideration of the privileges and immunities, the Global Center for Adaptation Order, published as legal notice number 82 of 2025, and laid on the table of the House on Thursday, 4th December 2025, and declares that the privileges and immunities, the Global Center for Adaptation Order, legal notice number 82 of 2025, a nullity for failing to comply with Section 17 of the Privileges and Immunities Act, Cap 179, that requires the regulating authority, regulation making authority, to submit the draft order for approval by Parliament before publication of the order, and infringing Article 94(6) of the Constitution, relating to the principles and Section 13A of the Statutory Instruments Act, Cap 2A. The member for Molo, you want to contribute to this?
So, Honorable Speaker, I really want to applaud this nullification of this particular instrument, Honorable Speaker. And I think this is also a call for this Honorable House to be very careful about the laws that we enact, because looking at some of the provisions that were contained in this particular act, Honorable Speaker, one of them was providing immunity from suit and legal processes for acts, omissions in official duties for these particular diplomats. They were being given exemptions from direct taxes or salaries, emoluments. They were being given immunity from national service. They were given immigration and registration exemptions. They were being given exchange control privileges and repatriation facilities. They were being allowed, Honorable Speaker, free importation of anything, duty-free importation of furniture, personal effects, household goods on first arrival. Honorable Speaker, all these privileges, in as much as we accept, Kenya has become a hub of diplomatic missions, global, Honorable Speaker. And as we welcome even the decision by the UN to really set up a substantial office here in Nairobi, that does not mean that we need to advantage foreigners over Kenyan citizens, Honorable Speaker. And of late, you've seen some of these privileges that are given to these foreigners, Honorable Speaker. They end up abusing them. You know, Honorable Speaker, just the other day you saw the Russian guy coming to this country and doing all manner of things, including breaching our data protection laws. We know the allegations, and the Honorable John Kagiri keeps talking about, Jane Kagiri talks about the intricacies being done to the people of Nanyuki by the British army people who are training there, Honorable Speaker. And therefore, it's very important in as much as we become very welcoming, and we really welcome all these foreigners to come and invest in our country, to come and live here, to come and set up the offices
What
here.
is this Russian thing?
But, so, Honorable Speaker, there is a Russian who ameshikanisha inchi a few weeks ago. Some Russian guy, he came, he was wearing these sunglasses that has cameras. He was picking up women all over the place and doing all manner of unimaginable things with them and recording them, and later releasing them. And some of them are very embarrassing, Honorable Speaker, and has really degraded, even though some of the actions by those women may not be upheld as good, Honorable Speaker, but recording them, some of them are mothers, some of them, it has broken quite a number of marriages, Honorable Speaker, because some of them were admitting they are married, but they were really willing to do anything to go with that white man, Honorable Speaker. And perhaps we have a discussion with some of my friends, and this is some of the what do you call it? When growing up, all the soap operas that are fed to our children and to our girls, now people imagine that the only romantic men are white people, or the people that are not black. And many women also believe that if you get acquainted with someone who is white, or then utatoka block, you will get out of poverty. And therefore, they are willing to really go out and do anything possible, Honorable Speaker, as a way of trying to safeguard their fortunes, Honorable Speaker. That is the story of the Russian guy. So it's very important, Honorable Speaker, that as we saw again last year, some Chinese employer, Honorable Speaker, slapping and beating up his employees. And I think we need to be, in as much as we need to be welcoming, this particular foreigners cannot operate outside the laws of our land. Whether it is our employment laws, whether it was the data protection laws, whether it is all those things that are criminal, those that are not, and we must safeguard our interests. Selfish, Honorable Speaker. If any of us goes and commits some of the crimes that these foreigners commit in this country, and we commit those crimes in their countries, Honorable Speaker, you will rot in jail in their countries. And it's a high time that as a country, we also take note of this. And those foreigners that break the lands of our land, they should be repatriated. We should ask them to be repatriated back to this country to face the full force of law, and they should be imprisoned here in committee, not taken back to their countries for imprisonment. Because like when Kenyans commit crimes in those other countries, some of them are thrown to jail. We have seen petitions coming from this house for members where they are saying some of their constituents have been jailed in India, others in other countries for years, for very many years for some very petty crimes. So we really need to be, not to allow again these foreigners to come from their countries to disrespect us, to disrespect our women, to disrespect our laws, to disrespect the laws of our land, and we should take as much as stern action to those foreigners as they will take on us if we committed those crimes in the respective countries. So for that, I really support the mover of the motion, the Honorable Gishimo, for this nullification. And again, we must be selfish as a country. And as much as we're opening our doors to foreigners to come in our country, it does not mean they come and demean us. It does not mean they come and take us as their slaves. They must come and follow the laws of our land. The same way, when you go to their land, we strictly adhere to their laws. And the same way they are strict on us if you break the laws of their land when they visit their land, the same way we should be strict on them when they come and break the laws of our land. I beg to support, Honorable Speaker.
Member for Jomvu, you want to speak on this? Member for Jomvu, this is your chance to contribute.
Yeah.
Okay.
Asante. Mheshimiwa Spika, mimi pia nataka kuunga mkono na kukubaliana na yale maneno ambayo Mheshimiwa Kuria Kimani ameweza kuyasema. Kwa sababu Mheshimiwa Spika, tukiangalia ni kweli katika hii hali ambayo tuna watafadhalisha hawa watu ambao wanakuja hapa kama mabalozi na watu wengine katika nchi yetu, baadaye wanatumia nafasi hiyo kufanya vitu ambao sio sawa. Mfano, tuweza kuona watu wageni ama kwa kizungu tukisema foreigners, ambao kama huyu ambaye ametajwa hapa kutoka Russia.
Amekuja hapa, amefikia wasichana wetu, amewatongoza, amewafanyia makosa, alafu amevunja nyumba zao na kila kitu. Mheshimiwa Spika, ni lazima sisi utu wetu tuweke mwanzo. Na mambo kama haya Mheshimiwa Spika, tukiangalia, unaona kama mabalozi pia ambao wanakuja hapa na wanakaa hapa, wanapata msamaha huu pengine wa kuweza kuagiza mali ama vitu vingine. Unaona mtu anakuja mkora fulani, ana import makontena ama magari, anasema ni personal effect za balozi fulani na halipi ushuru ambao ni wa nchi yetu.
Mheshimiwa Spika, si jambo la sawasawa katika huyu Mrashia ambaye alituchezelea watoto wetu sana. Nataka kuambia Mheshimiwa Spika, ni kwa kuwa sawa sawa kabisa, asihukumiwe mambo ya kuwekwa jela. Ye matatizo yake ni zile chengelele zake ambazo kwa amezifunga kwenye suruale. Ni vizuri, kwa kizungu zinaitwa ziwe castrated, yani afinywe na hayo maneno ili asirudie maneno kama hayo. Mheshimiwa Spika, leo huyu mtu mimi nashangaa, Mheshimiwa Spika, amfikia mpaka mwalimu wangu mmoja nasikia sijui wa Mikindani kama wapi, uliza mimi niko single kwa sababu ya ule Mrashia. Je, leo mheshimiwa ingekuwa amefika katika sehemu ambazo ameweza kueneza ugonjwa na mali pengine, sisi tungekuwa kwa hasara. Kwa hiyo Mheshimiwa Spika, nayaangalia mambo haya kwa mambo mema, lakini tuyaangalie kwa tahadhari. Asante kwa kunipa nafasi hii, nashukuru sana, na twalaani maneno ya huyo Mrashia. Asante.
You are all now confusing the House. There definitely is a difference between the Global Center for Adaptation and the Russian. Please go ahead and tell us the difference.
Mr. Speaker, you know sometimes in a very hard topic like this one, you take leave to discuss other issues of national importance. Mr. Speaker, I rise to support this, the Committee on Delegated Legislation's report, which is very important. And Mr. Speaker, this committee did not go into the merits of that particular order. As you have just heard the Chair of Finance, the Honorable Kuria, he has vividly stated that there are issues with regard to this order. We should have gone to the Minister of Finance because it includes tax exemptions. Now, on question of tax exemptions, it cannot be done by the Minister of Foreign Affairs. This is a matter which can only be undertaken by the Ministry of Finance in accordance with the Constitution. Mr. Speaker, as you know, there's a plethora of laws, of decisions by the courts, which have held that procedure is as important as a substantive law itself. In this case, Mr. Speaker, the procedure that was adopted in seeking to grant immunities and privileges to this particular organization was complete in total breach. The law requires that that order must be brought in draft form to this House for approval before it is gazetted. Now, what happened, Mr. Speaker, this order was gazetted and it came into force irregularly, completely out of procedure. As you know, Mr. Speaker, anything that does not adhere to establish legal methods, rules, and regulation is of no effect. It is null and void. The reason why we have procedure, Mr. Speaker, it ensures that it prevents arbitrariness on those that are given power to make regulations. It ensures that we avoid chaos in lawmaking, Mr. Speaker, so that if procedure is not followed, everybody will just be coming up with anything that does not follow the law. And as you know, Mr. Speaker, Article 94 of the Constitution is very clear. It states that there is no person within the boundaries of this country that can make anything that has a force of law without the authority of this House, without the authority of Parliament. So, Mr. Speaker, anybody who attempts to grab the power that has been granted exclusively by the people of Kenya to this House, it will be frowned upon. And so, Mr. Speaker, the intention of having procedures is not to stifle the making of laws, but it is to ensure that there is fairness, there is justice in the manner we enact laws. As you know, Mr. Speaker, the courts will take a dim view on any person who fails to comply with procedure as laid down by this House. This will ensure that these procedures, Mr. Speaker, regulate rights and privileges that are enjoyed by Kenyans and any person who comes into this nation. Just to mention just a few things that we noted, Mr. Speaker, which we did not put in our report if we are to deal on the merits of this matter. Mr. Speaker, this is an organization that was established in the Netherlands. And it came into this country having been registered in that other country, Mr. Speaker. And we wanted to know why it deregistered itself in that particular country. Mr. Speaker, there was no public participation that was undertaken, as required by Article 118 of the Constitution and Article 10 of the Constitution. So, Mr. Speaker, clearly, this was in total breach of the Constitution. So this order in itself is unconstitutional, Mr. Speaker. So I support that this order be declared null and void by this House. And therefore I support. I thank you, Mr. Speaker.
Member for Funyula.
Thank you, Honorable Speaker. Let me also join the Committee of Delegated Legislation, or rather let me support the report of Committee on the Delegated Legislation on recommending to nullify in its entirety the privileges and immunities the Global Center for Adaptation Order published as legal notice number 82 of 2025, based on the facts that have been presented to us by my good friend, the MP for Gishugu, who happens to be a member of the committee. And Honorable Speaker, for record purposes, I was a member of the committee in the last term, but this term I've not been a member of the committee. Honorable Speaker, the Global Center for Adaptation is an international organization that was established as part of the Paris Agreement on climate change resilience and climate change management. Its headquarters is in the Netherlands, and of course the fundamental questions that we need to start asking: to what extent, whether there is a diplomatic mission or not, that's a question we need to answer, and probably in the fullness of time, we need to have to ascertain that particular notice. But Honorable Speaker, the mere fact that the State Department for Foreign Affairs proceeded to publish and enforce the order without the approval of Parliament is the highest level of impunity, is the highest level of breach of the Constitution. Honorable Speaker, truth be told then, whoever appended his signature or her signature in getting the order published breached the Constitution, acted unconstitutionally, and therefore, Honorable Speaker, is liable for a sanction probably under the various articles of the Constitution of Kenya, because you cannot purport to be a public servant who have sworn to uphold the Constitution, and you are the very first person to disregard the provisions of the Constitution and proceed to publish the order and get it enforced. I would want to challenge the committee. I can see the chair and the vice chair are in animated discussion. You need to ask whoever signed and published the order to really come and account for that unconstitutional edict. To be honest, we cannot allow that level of impunity to prevail and go unpunished. That is unacceptable in the modern day. Honorable Speaker, we tend to favor these diplomatic missions even beyond what we do to our own people, who slug out day and night to get things moving. And I want to commend the committee for having stood up. I'm sure there must have been a lot of pressure from the executive or other corners to get it passed. But at least for the very first time, your side had the courage to say no and to uphold the constitutional provisions. Honorable Speaker, we even ask Kenyans, when we go out of this country, for either at work or not, I've been to very many missions, talking to diplomats there, and they're very clear in their views. They say they have to comply with the laws of the country. The diplomatic immunities that are accorded is only for the mainstream diplomatic missions that are truly and purely accredited by that country. And whichever way, there are some things that are a no-go zone. Things about taxation, things about having immunity against criminal action is something that is beyond. This cannot be entertained in those countries. Why us here in Kenya, we allow that kind of a thing to happen and then let these foreigners go scot-free is baffling. It's just a continuous act of dereliction of duty for those people charged with those offenses. How many, Honorable Speaker, there are very many times foreigners commit offenses, they're scripted away at night, so that by the time they have to answer for those offenses, you are told they are no longer in the country. As I stand here today, Honorable Speaker, the man who was being beaten in Eldoret by the Chinese comes from my constituency. I asked a question here, they have never received an answer. The gentleman was badly injured. Nobody has ever bothered to attend to them. In this disguised view that we want foreigners to invest in our own country. As Baba Mo used to say, nobody will come from anywhere to develop this country. We have to do it ourselves. And if we have to do it ourselves, we must be extremely hard on these foreign investors who come to with nothing most important to invest and get us done, get moving. As I conclude, Honorable Speaker, I want to urge the committee to remain courageous in view of the intimidation normally have to receive, remain courageous, and God will forever remember that you existed and probably save this country from one of these funny things that is going to happen. Thank you, Honorable Speaker.
The member for Marsabit.
Thank you, Honorable Speaker, for giving me this opportunity to add my voice to this very important debate. And from the onset, I support this motion. And Honorable Speaker, I support it because of the experience that we are having in this country of late, and even in the past, because many of our citizens have suffered in the hands of foreigners. And I support this because the committee has made the right observation. And I like what they have said. Number 4, having examined the Privileges and Immunities Global Center for Adaptation, Order 2025, Legal Notice number 82 of 2025, in accordance with the Constitution, the Interpretation and General Provision Act Cap 2, the Statutory Instrument Act Cap 22A, and the Privileges and Immunity Act Cap 179. The committee recommends that the House declares Privileges and Immunities Global Center for Adaptation, Order 2025, Legal Notice number 82 of 2025, nullity for failure to adhere to Section 17 of the Privileges and Immunities Act. This, Honorable Speaker, is a serious gap that the committee members have observed. And I want to congratulate the members of this committee for standing in the gap and salvaging the situation. Honorable Speaker, if we cannot nullify this today, many Kenyans will suffer in the hands of foreigners who come in the pretense of investing in this country, starting companies that can employ our young people, and at the end of the day, many Kenyans suffer in their hands. The example that many honorable members have referred to is something that has moved the entire nation and the entire world. And just remembering the number of our young people who have been maybe infected by that particular Russian man is a story that will affect us for the rest of our lives. And many families, and I know many young people, many women today may be depressed of this. Honorable Speaker, we know very well that many investors have come and have mistreated members or citizens of this country. Some have even taken some very important documents from them, hidden their identity cards, their passports, mistreated them, used them as their workers, social workers or workers, and at the end of the day, without even paying them. And Honorable Speaker, nullifying this will save this country and also will give us our pride that we need. And with those few remarks, Honorable Speaker, I support. Thank you.
Thank you. Member for Gases. Thank you so much, Mr. Speaker, for giving me this opportunity to also rise in support of the report of the Delegated Legislation Committee on the Privileges and Immunities, the Global Center for Adaptation, Order number 2025. And from the onset, Mr. Speaker, I rise to support the recommendation of the committee in rejection, in annulling in totality this particular order that was developed and published by the executive in absence of what the law has guided, that all the laws-making procedures is vested in this House, and the instruments of power as guided on the same. Mr. Speaker, this one is just a troubleshooting, and it could be inviting this House to extend its role in ensuring that we carry out an audit to establish all the instruments that are being used to run these organizations, to run the ministries. Because if this thing was done in silence, in contravention with the law, and was already deemed to be giving out powers to a foreign person, in this case, the Global Center for Adaptation, powers to up to including contravening the Tax Procedures Act, where all powers on exemption of taxation, as per the Tax Procedures Act, is now in the office of the Cabinet Secretary for National Treasury, of course in consultation with the relevant ministries when a matter arises. But all the powers are in the hands of the Cabinet Secretary for National Treasury. But already looking at this instrument, it was already subverting that power and giving out an advantage, a privilege to a foreign entity. And most of this issue is coming up because of the current occurrence in our nation, where we've seen friends who have been invited to the nation, friends who have come in goodwill. Some of them have come to facilitate the foreign direct investments. Some of them have come to give services in support of what government is doing in addressing the social needs of the people. But they end up abusing these particular privileges to carry on their interest, up to including exploiting our children in terms of the information that is not warranted for our young people, exploiting our women, exploiting our population in terms of labor. Some of them have come employing our people, using them beyond the limits without proper compensation, and even to an extent of coercing, an extent of subjecting them through stress, subjecting them through behaviors that our employment laws are totally against, just by virtue of the cover they've been giving. So with this one, I want to say that this House has done the right thing. I want to thank the Committee on Delegated Legislation, I see the Vice Chair is here, that they are doing the right thing, so that it's able to alert this House, so that we be keen. And remember, this House is established to protect the interest of Kenyans against all odds. And for this purpose, it is high time that the ministries, led by this ministry, should do the right thing, involve this House, because it's only this House guided by Article 118 that they can undertake proper public participation and public sensitization, stakeholder engagement, so that we're able to balance and don't cede out the privileges for our people at the expense of foreigners. So I want to support this particular motion and to say this serves as an example. We need to go further beyond here so that we safeguard the interests of Kenyans. Thank you so much, Mr. Speaker. Thank you. Member for Baringo, what happened to your card? Go ahead.
Thank you, Mr. Speaker, and sorry for not having my card ready for this time. Mr. Speaker, I also want to join my colleagues in supporting the work of the committee, and specifically Honorable Gishimu for moving this, because, Mr. Speaker, I keenly read this report, and I'm shocked that someone in the echelons of power or executive would even think for once that he can just break the law with all the disregard of even bringing this draft to Parliament. Mr. Speaker, I was so keen in the schedule of the Act, which was rejected by the committee, and this exemption of certain taxes and duties, and inviolability of premise and official archives, and even the immunity from suit and legal process. Mr. Speaker, this is a very dangerous organization. You can imagine someone seeking not to be subjected to any law of this country or of the land of Kenya, just because you probably want to do something that is unimaginable. And many times, Mr. Speaker, I think for once, Africans should be happy being Africans. We don't have to hate, we don't have to look forward to be associating so much ourselves to these whites and imagining that they can do a lot of better things than us. And if you read history, you realize the industrialization and civilization of the world actually started in Africa. So I think I want to thank the committee for once because of refusing to be coerced and standing and protecting Kenyans by refusing this order to go through. Mr. Speaker, in previous times, I come from Baringo, and there was this runaway acceptance of global climate solution, sort of, where someone, I think it was from Canada or Brazil or wherever, decided that during Moi's time to come and help people of Baringo from mitigating desertification. And they brought this wild plant called madenge, which was accepted probably those days. But the adverse problems is being felt by the people who are not there and who did not make the decisions. So when someone makes a decision today, it doesn't affect them probably now. But when you're out of office, it is going to affect people who are very innocent. And it is very important for us as a member of parliament to continue protecting the people of Kenya and allowing things that can actually progress through the law. And also, I want to also thank the committee because the section of the privilege and immunities must pass through parliament. As long as this draft or this order did not pass parliament, it should not be allowed. And I hope the executive are not going to sneak this as a part of the privileges they have also, because they are feeling that their offices are important. Mr. Speaker, other issues, just like the way members have been complaining about the Russia and this Russia guy or this Russia man, I can't imagine the impact that he left. The terror that went through people's houses, the emotions that created through these young women or these exposed women, the problems that they are facing now in the society, the judgmentals and all those kind of things. Just because we allowed someone to run around, take photos, and up to this point, we have never seen a proper actionable, reasons or someone to take up and give us reasons why this guy, how did he even land in Kenya and what was he doing? And so that we are able to protect ourselves. Mr. Speaker, if you look at the way Africans generally behave, we are so welcoming and we always attract such kind of characters. And this is one of the reasons I want to thank the committee for studying firm and with finality nullifying this order to proceed. Thank you, Mr. Speaker, and I support the committee.
For Mungi Central, want to contribute to this?
Thank you, Mr. Speaker, for giving me this opportunity to contribute to this bill. Mr. Speaker, I rise to support the report by the Delegated Legislation Committee on their report on the privileges and immunities regulations for foreigners and foreign missions. Mr. Speaker, I would like to support the annulment of these regulations because they are against the Constitution of Kenya 2010, which states that no one is above the law in Kenya. Anybody can sue and anybody can be sued in Kenya, except the President of Kenya when he's in power. Further, Mr. Speaker, the fact that the regulations were allowing exemption of taxes, this is contrary to the law, and anybody in Kenya earning a salary in Kenya must pay taxes in Kenya so that we can run our country effectively. And this, Mr. Speaker, will have opened a Pandora's box for others to join in and misuse their power and exploit other Kenyans on some of these exemptions. Mr. Speaker, this House should set a good example for those in power and for those in the executive, that you cannot wake up one morning and prepare your regulations to suit yourself and your friends and your cronies, so that in the future, they should know that there is a House of Parliament which makes laws and approves regulations. Mr. Speaker, to make such kind of regulations without consultation to Parliament, without public participation, is indeed usurping your powers to circumvent the law. And therefore, Mr. Speaker, this was illegal and should be treated as such, and therefore, let this annulment by the Delegated Legislation Committee set an example to those in the executive to abide by the rule of law in Kenya. Thank you, Mr. Speaker.
Thank you. There being no other interest on this, I would like to call upon the move of the Honorable Gichim to reply.
Thank you, Honorable Speaker, and I want also to take this opportunity as I reply to thank all the members of Parliament who have contributed and supported this motion. Actually, there is no single member who has opposed it. And just to indicate and to clarify to Honorable Oundo that the mandate of the Committee on Delegated Legislation is limited and, or actually is provided under Standing Order number 210, 3 and 4. And the best that this committee can do is, after scrutinizing the statutory instruments, is to recommend approval where compliance to the law and the requisite procedures has been met or have been met, and to recommend an annulment by this House, which we have done, whereby the requisite law, the Constitution, and the standing orders have not been followed. So that is the limit of our mandate, and actually we've done what has been provided for under the standing orders. So I also thank the committee for being the gatekeeper of the Kenyan citizens through this parliament, that all the regulations, all the statutory instruments that are brought before this House through Parliament must also follow the law. And as a parting, as I finish, Honorable Speaker, it has also come to our knowledge as a Committee on Delegated Legislation that there are instances that the executive and some regulatory making bodies, they do what they normally call internally as directives, and those directives have a force of law. we want to caution them that anything that has been made and has a force of law with even consequences, that if you don't obey, you are supposed to face some consequences or some penalties. Those are statutory instruments and they should be brought to Parliament for consideration as provided by the Parent Act under which they are made. So, Honorable Speaker, without much ado, I beg to reply. Thank you, Honorable Speaker.
Thank you, and honorable members, for obvious reasons, we defer the putting of the question on that particular motion to the next time listed in the order paper. Next order.
Order number 14, motion, consideration of a petition regarding discrimination by the Teacher Service Commission on career progression guidelines for special needs education teachers in Kenya. Resumption of debate.
Members, debate on this motion started on yesterday, actually. And so if there's any member who has interest on this, if there is no interest on this, then I would order that the next time it comes up, the mover is called upon to reply. Next order.
Order number 15, motion, 7th report on the audited accounts of the National Government Constituencies Development Fund Board for the financial years 2016-17 to 2021-2022.
Are you ready to proceed with this? I see you got a number of them today.
Yeah, Mr. Speaker, I request that you allow me to move this motion next week because I was not fully prepared for this. And based on the members present, I have one member here who can second me, but we are not prepared to move the motion today. We thought it was too far in the order paper. Thank you, Mr. Speaker.
I would imagine that now you are informed about this, but then we stand down that order 15. Next order. Is it the same for, go ahead.
Order number 16, motion, 8th report on the audited accounts of the National Government Affirmative Action Fund for the financial years 2016-2017 to 2021-2022.
Is it the same?
Same, Mr. Speaker.
For the comments of the House, could you please call order 18 first?
Order number 18, motion, 9th report on the audited accounts of the National Government Constituencies Development Fund for constituencies in Nakuru County for the financial years 2013-14 to 2021 and 2022.
Honorable Mulungi, this is
it's the same.
It's the same matter. So
yes,
orders 18, 16, and 18 are stood over until next time they're in the order paper. Let's go back to order number 17. Let's go back to order number 17.
Order number 17, motion, report on the audited accounts for the Judiciary Mortgage Scheme Fund for the financial years 2011-2012 to 2021 to 2022.
Is the chairperson in the House? Who is the chairperson? Oh yeah, Dr. Fatuma had indicated that I think Ramadan, so she won't be around, but it's over generally. Next order. Next order, please.
Order number 19, the Energy Amendment Bill, Senate Bill number 42 of 2023, second reading.
The Honorable Vicaria, you got 18 minutes. You able to move in those minutes? Okay, go ahead.
Not a very big issue. Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the House adopts the report of the Departmental Committee on Energy on the Energy Amendment Bill, Senate Bill number 42 of 2023. Honorable Speaker, the bill seeks to amend the Energy Act, Cap 314, by introducing a new section, 134A, to regulate energy purchase agreement and power purchase agreements entered into between power producer and electricity buying entities such as Kenya Power. The main objective of the bill, Honorable Speaker, is to enhance transparency, accountability, and prudent financial management in the procurement of electric power and to protect consumers from inflated electricity costs arising from non-transparent contracts. Honorable Speaker, the bill was published on the 30th October 2023 and read for the first time on the 24th April 2025. It was thereafter committed to the Departmental Committee pursuant to Standing Order number 127. In compliance with Article 118, Honorable Speaker, of the Constitution, the committee invited public participation and received submissions from the Ministry of Energy and Petroleum and stakeholders in the energy sector. In compliance with Article 1181B of the Constitution and Standing Order number 127.3, through the placement of adverts in the print media on 15th May 2025, the National Assembly invited the public and interested stakeholders to submit memoranda on the proposed amendment. Honorable Speaker, by close of business on the 28th Wednesday, May 2025 at 5 p.m., the committee did not receive any memorandum on the bill. Honorable Speaker, the committee invited Minister of Energy and Petroleum for a meeting on the 29th July 2025 to give their comments and proposals on the bill. In addition to the committee invited other stakeholders, including All Power 4, Kipeto Energy PLC, Socian Energy Limited, and Lake Turkana Wind Power Limited for a meeting to give their comments and proposals on the bill. It is important to note that out of the stakeholders invited, apart from the ministry, only Socian Energy Limited appeared before the committee. Honorable Speaker, the committee carefully reviewed the bill clause by clause and considered all views received. Honorable Speaker, after considering the bill, the committee made the following key observation. 1, the bill refers only to energy purchase agreement. However, in practice, Honorable Speaker, Kenya Power enters into both energy purchase agreements and power purchase agreements. The two are different. Power is measured in megawatts, while energy is measured in megawatts per hour. The law must therefore clearly cover both to avoid ambiguity. Secondly, the proposed section 134A2 restates principles of public finance that are already provided for in the Constitution and other existing laws. The committee found this as unnecessary duplication. Thirdly, the proposed subsection 134A3 introduces procurement and feasibility study requirements that are already covered under the existing frameworks, such as the Least Cost Power Development Plan and the Public-Private Partnership Framework. The committee noted that retaining these provisions may create legal conflicts and delay energy projects. Mr. Speaker, in view of this observation, the committee recommended that the House approves the bill with amendments. The key amendments proposed are: 1, to introduce a clear definition of energy purchase agreement to include both energy and power purchase agreements. 2, delete Section 2 to avoid duplication of constitutional principles. 3, to delete Section 3 to avoid legal conflict and unnecessary delays in procurement. And lastly, Honorable Speaker, to provide a transitional clause requiring existing agreement to comply with the law, with the new law within 6 months of commitment. Honorable Speaker, energy is a backbone of our economy. It affects industries, small businesses, households,
and all the overall cost of living. While transparency and accountability in energy contracts are essential, we must also ensure that our laws are clear, consistent, and workable. The committee believes that the proposed amendment strengthens the bill to align it with existing law frameworks while protecting public interest. I therefore urge honorable members to support the report of the committee and approve the bill with the proposed amendment. Honorable Speaker, this is an amendment that came from the Senate and proposed by Honorable Sifuna, Senator Sifuna. He was trying to clean, but when we looked at the bill, as I've indicated, Honorable Speaker, it actually was a repetition of already the existing laws that are already there. And other than an exception of only one clause that we were bringing to the amendment on the definition to include both energy and power purchase agreement, Honorable Speaker, all the other proposals that he had proposed, we thought it was just a duplication and it might bring some conflict in future if allowed to go through. Honorable Speaker, I beg to move and ask my brother to second. Mheshimiwa Geshimo Wakili, asante.
Okay, I don't know he was your brother, but yeah, brother, Honorable Petition.
Honorable Speaker, in our custom, we call men of almost the same age brothers. So I believe that is where he is coming from. So, Honorable Speaker, let me second. I rise to second this bill, which has been moved by Honorable Gikaria. And Honorable Speaker, the committee has carefully considered the amendments that came from one of the members of the Senate, Honorable Sifuna, and thought is wise that there is no need to pass the amendments as they are in the bill, because that would amount to a lot of duplication on the existing laws already. And Honorable Speaker, the part that requires definition, which has been creating confusion and probably jeopardizing and compromising the consumers in terms of the power which is built. I think this is a debate that has also has found its way into this House through various members. I remember the Honorable Member for Laikipia, Honorable Jen Kagiri, brought up this matter, and which even went to the Energy Committee. It was deliberated there. Actually, the report was even brought to this committee. And Honorable Gikaria has picked it from there, actually, through that amendment. Now that issue will be resolved. And to be fair to the existing agreements, the partners or the parties to the existing agreement, that exit clause is very, very important, so that, because law does not act retrospectively. So there could be some timelines they had already given themselves in those agreements. So that exit clause is also very, very important, and it ensures there is fairness even to the existing parties in those agreements. So, Honorable Speaker, since it's just one main clause with the sub-clauses that is being sought to be amended, I don't need to go beyond that point. I beg to second. Thank you, Honorable Speaker.
Members, I propose the question that the Energy Amendment Bill, Senate Bill number 42 of 2023, be now read a second time.